background noise. Thank you guys. I see you've muted yourself, so I appreciate that. And I'm sure Ken, as he's talking, I'll appreciate that as well. So I'm going to mute myself too, Ken, and let you take over. And Kenneth said if you have program questions during the program, to just kind of to interrupt with your question. Is that correct?
That is correct. There's there's
Okay.
a chat button, and then you can also say someone's on. That way, I'll
Okay,
try to
sounds
answer
good.
as long as it's on that topic.
Okay, well, I'm going to mute myself now so you can go ahead and you won't hear my background noise.
Thank you. So welcome, everyone. My name is Ken Vercammen, and I'm an attorney in Edison, New Jersey, and I'm trying to help people out and give people some advice. So we're going to start off with, well, what has changed this year that was different in the past? Well, I used to have people coming into the office, and I wouldn't see anyone unless they came in and you filled out the form, etc. Well, people don't want to leave their house, or my staff doesn't want them to come in the office. So in a way, we became more efficient. So rather than like just sending someone a letter or an email saying, fill this out and bring it with you for the appointment, we say, okay, you can get these types of documents done without even leaving your home prepared. So to assist clients and seniors, many attorneys now are offering document preparation remotely in consults because we're concerned about people's health and well-being. So what we typically do is attorneys will email a questionnaire to everyone. And what people do is they type in a response rather than handwriting something. They type in. We're going to get into the documents, but the documents aren't going to be that complicated because basically we want to know, let's say, what's your name? Are you married? And then we go further from there. So, but let's also talk about, sometimes people say, well, why do I need to have a will? I'm married. All my accounts with my spouse are joint. I goes, well, that's bad planning because both of you are not going to live forever, and you want to be able to have the type of planning for the future, not just like for the one spouse. So if someone does not have a will, number one, the procedure to distribute assets, if someone is not married, becomes much more complicated. So it would require all the children to agree upon who's going to be what's called the administrator of the estate. It requires all of the children who are not the administrator to sign a formal renunciation affidavit in front of a notary, and then have it forwarded to the court. And if all the children do not sign this type of renunciation affidavit, then a complaint order show cause has to be filed with the Superior Court, costing over $3,000. So, someone doesn't have a will, they think they're saving money. They're not, because they're putting that expense upon the family. And people are often saying, oh, well, my kids are all get along, they'll do stuff. I goes, well, never assume. And even if they get along, let's say during the shutdown, it's difficult to find a notary. Where were your notaries at? Your notaries were at the banks. Your notaries were at the library. Well, what's closed? The banks are closed, the libraries are closed. So where's our notary? Well, aside from the UPS store, by appointment, there's no places. Also, if someone does not have a will, or it was not valid because it wasn't signed properly, prepared properly, there's an additional expenses because the person who becomes the administrator has to take out what's called a surety bond, spending over $1,000, and that's per year. And some people don't have the credit to qualify. That's also if there's, if someone has minor children, a judge who's a stranger determines whose custody. But just think, do you want to cause more stress and aggravation amongst the family? When loved ones are grieving and dealing with the passing, they shouldn't be overwhelmed with what to do next. This is why you plan ahead of time. No one would decide on a Friday afternoon, you know what? I'm going to go on vacation for 2 weeks now. I don't know where I'm going. I'm just going to jump into my car and start driving until I and decide where the fork takes me. Um, Part of doing the documents is to make sure that the people you like are receiving your assets. And more, people are saying, do I have to leave everything equal to my kids? And the answer is no, no, you don't. So many times people said, you know what? I would rather have it go towards my grandkids, but not my children, because my kids already have a house, they already have kids, but I would like to have this put aside for the grandchildren's education because, like, going to Rutgers or University of Scranton, it's very expensive. So think about if you don't have the documents, who do you want to get your assets and who you don't want to get their assets. A client came in the past year and said, again, do I have to treat all my children equal? I goes, no, it's your decision. What do you have in mind? What are your wishes? What do you have in mind? And she said, well, I have a son who lives on the West Coast and we don't hear from much. I said, okay, well, let me ask you a question. On Mother's Day, did he get a card or a call? She said, no. On your birthday, did he get a card or a call? No. How about on Christmas? Did he get a card or a call? No. So I said, well, then why should that person even get anything? It's your right to determine who's going to get your assets. So let's think about, people. It's the mystery. Oh, I don't want, I'll get around to it. I'll get around to it. I'll get around to it. Well, no one looks forward to cleaning your garage or cleaning the basement, but once you do it, you're like, okay, good. I'm glad they put that behind me. So attorneys, try to work with people. So the questionnaire myself and other attorneys will send out, ask questions. Okay, let's see, where do you live? We also recommend powers of attorney and living wills. I'll touch upon that. Now, the will the person who is in charge, the captain of the ship after someone passes away, is called an executor. There's an executor number one and an executor number two. Let's see. You never want to have joint executors because that means that two people have to do everything. And even if they could be twins living together, but why create twice as much work? Why require that two people got to go to the surrogate's office, two people got to meet with the realtor to sign a listing, two people have to sign the contract for sale of the house, two people got to sign addendums, two people have to go to closing, two people have to go to every bank, two people have to sign every check. And sometimes you get people who don't get along. So there's a reason why there's only one steering wheel and only one captain of the ship. So you have an executor one, and then you had the executor number two. And this is why I tell people, and it also, for your executor, banks will not become your executor unless you have a lot of money. So if you have less than $2 million, $3 million, the bank won't be an executor. Also, even if you're leaving assets to charities, those charities will not be the executor. One time I called up a charity and I said, listen, a person wants to make you the, you're getting everything. How do you want it listed? Who's going to be the executor? Is it the CEO? And they goes, no, we won't be the executor. I said, well, you're getting $350,000. He goes, no, we won't do that. Just send us the money. Well, there's no one to be the executor. So think about who you want. Next, now, believe it or not, New Jersey did away with the tax. Wow, who would have thought that? They did away with the tax. Well, they did away last year with the New Jersey estate tax. Now, there is a federal estate tax. However, that starts at $11.5 million. And not too many people I know in the Metuchen Edison area have more than $11.5 million. But we still ask, do you own any real estate? And then after that, what's the ballpark amount of your other assets? We ask about real estate because A will that's done in New Jersey is valid in any other state, but for every state you have real estate in, there has to be a probate in that state. Now, probate in New Jersey is easy. In other states, probate is ugly. Probate's a dirty word, but probate is easy, and all it requires is the executor taking the original will, death certificate, check for about $150. Let's say they they meet with the surrogate, and it's interesting now that the surrogate's offices are closed, but we help clients sign the proper affidavit, so the surrogates are still admitting wills to the original will to probate. Got to be the original will. So if you have a will, you can't find the original, go out and get a new one done. If you can't find it, your family can't find it. So we also, though, ask people, for your assets, are there any assets that have direct beneficiaries? What do I mean by that? Well, certain assets pass by title and not by a will. An example of that is people have, married people own houses. So the house, if it's owned husband and wife, if one of the two passes, it goes to the surviving spouse. Let's see. So that's where it passes by title. If a bank account has POD, payable upon death, or a joint tenancy, that passes by title, whoever's on the other side. There are other assets that pass by contract. Examples of those are 401k, IRA, life insurance, annuity, pension plans, anything that has a beneficiary. So a will can't change that. So we ask people, and we also recommend that people double check for assets that they own to to get a printout, just and you keep it in your will folder, just where it'll say, okay, these are some of my accounts, and this sets forth who the beneficiary is. Part of planning is making it as easy as possible for the family so that they don't have to they have to do less work during the grieving process. So next you have to decide who's getting your stuff. So our questionnaire says, okay, who's the beneficiaries? And if any of those specific people pass, who would receive their assets if they passed away? So the I call it the traditional thing is where it's going to spouse, then the children and the grandchildren. It says in the event that any of my children don't have children, it goes to the surviving children. However, you also, some people differ. More and more people are saying, you know what, I'm going to leave my assets to the charities and the people who care about me and have been by my side and have been helping me out. And as long as someone is competent and they can tell me what they want, someone wants to have a new will and says, listen, no, I want to change it to this person, that person, and they're competent, then they're good to go. Sometimes, though, some people can't get out of the house. They're ill, they're in the hospital. Now, when we used to be able to go to the hospitals and care facilities, but we would want two things ahead of time. Number one, we would need to see a note from a doctor saying the person is competent to do whatever document that they wanted. Will, power of attorney, living will, sometimes a deed. But I also want to talk to the people ahead of time to confirm that's what they want and not what a family member, told them they want. My mother-in-law used to call me every other year and say, oh, I want to come and get a trust done. And I would ask her the question, were you watching Susie Orman on TV? And she says, oh, yes. And I go, well, Susie Orman is right if you live in New York, Florida, or California, where the probate process is very, very complicated. So you want to have that $3,000 trust set up and put your assets to be owned by that trust. But New Jersey, since it's a probate easy state, I usually ask people, tell me why you want to spend $3,000-$4,000 setting up these different trusts when a $500-$400 will do the job for you. And again, I love I love new business and making money, but it has to be what is best for everyone. Um, some people also will, sometimes will say, do I have to treat? Can I give 20% to one, 10% to another? I said, yeah, that's your right. You can do whatever you want as long as you are competent. Now, some people also have what's called specific bequest. What is a specific bequest? Well, some people have specific amounts they want to leave to a person or entity. Mom might say, I want all my jewelry to go to my granddaughter because I know if my son is the executor, he will bring it to Cash for Gold and say, what will you give me for this junk? Let's see. Sometimes the men say, listen, I want these firearms to go to my nephew because he has a firearms ID, and otherwise a firearm cannot go to someone that does not have a firearm ID. Some people leave amounts of money to their church, to their school, wherever. If people say, listen, I want to leave X amount of money. If my estate is more than 200,000, I want to leave $10,000 to St. Francis School in Metuchen. Let's see. And when we leave to charities, we usually have a clause so there's no confusion. If the charity ceases to exist, what happens with that money? So sometimes schools close, churches close, no, we want to make sure everything is clear for everyone. All right. Now, sometimes people have what we call a reverse specific bequest. And I refer to that as I make no bequest to whomever. I'd say you don't have to leave $1 to someone. You just write in, and you don't have to put a reason. Just simply, I make no bequest to whichever person, and you don't have to put a reason. And by the way, after the will is signed, it is the person's decision whether or not to give copies to people in the family or only give a copy to the executor. Now, a will always has a clause to say, hey, what's going to happen if if someone who's under 21 is going to get things, grandchildren, great-grandchildren. So we always have a clause that says if anyone is under 21, they don't get the money. The money is to be held by the executor and used for college maintenance and support. People, though, that have minor children right now, oftentimes will say, they take my advice and I say, listen, we don't want to let someone who's 18 get any money. Oftentimes when there's minor kids, we say they get some when they're 22, some when they're 25, the balance when they're 30. But as much money as is needed can be expended so that the executor can pay for their college, pay for their support, but it doesn't require that they pay for their support. So, for example, the executor's holding money for minors, the parents have passed, and now they're 21 years old, they haven't gotten the money, but they are graduating college, and they say, listen, I got a job, I'd like to have you use the money to buy a condo. Well, the executor can say, okay, that might make sense. Someone could say, listen, I'd like to, I finished with school, I'd like to buy this business or invest in this business. Okay, that makes sense. On the other hand, one of the minors says, you know what, college, college isn't for me, I'm having trouble with college, and it's very stressful, and I need to find myself and relieve the stress, and I need $100,000 so I can go on a trip across Europe with my friends. The executor's going to say, no, you better work more hours at your crummy job because I'm not taking your parents' money. Your parents work so hard for that money, and I'm not going to let you use that kind of money. All right, so you meet with the attorney. I usually say to people that people should. Uh, if you got questions, you write down your questions. There's no question that's a dumb question except where you forgot to ask it and you never ask it. Let's see. But we do want to know if anyone is receiving social, anyone under 62 is receiving SSI or Social Security disability, because people that are receiving SSI or SDD could lose their entitlements, under federal law. So we asked that question. What we were involved with in a state matter where mom smartly did not leave anything to her 53-year-old son. Her son was an alcoholic, and her son, had difficulty holding down a job. But you still love the son. You want to take care of him. So she said, "Listen, his share is going to be about $100,000. I'm going to have it held into a trust by my daughter, who's the executor, and that's called a spendthrift trust. So it's a trust within the will. In that way, those monies can be held and used by that daughter for paying his rent, paying his car insurance, making sure that he had some food on the table." But we know that if you give an alcoholic $100, the alcoholic will buy $100 worth of booze. So instead, the trustee would buy ShopRite gift cards, which, in $25 increments. That way he was able to go and buy food and supplies, but it couldn't be used for booze. And also the $25 cards are not as valuable on a resale. Right? If you give someone a $50, American Express gift card, they might sell it on the street for $10, but and someone can buy booze with that. So that's why the person bought ShopRite gift cards. So now there's 5 main types of wills. Number 1 is parents with minor children, where there's a trust set up where the children get the money when they're 22, 25, 30. Second, it's like the type 2 will, where spouse has passed or they're divorced and they're giving money to the kids. Number 3 is basic unmarried. Type of will 4 is parents without a trust, where there's no minor kids. And number 5 is where people are married, but you're not giving the money outright to the spouse, but you're setting up a trust within the will for the benefit of that spouse. So why would you want to do that? Well, an example is second marriage situations, because people are kind of confused and not thinking ahead. Second marriage, people would come in and they'd say, well, okay, we want to have a will done. I want to leave everything to my spouse or to each other, but then when we pass, it gets divided equally between our 2 families. It goes, no, that's horrible estate planning. Bad, bad, bad. Don't do it that way. And they say, why? He goes, well, after you pass, they can have a new will and leave it to their new spouse. And he goes, well, oh no, they would, they both say they would never get married again. He goes, well, yeah, when you're married the first time, you weren't planning on marrying a second time. Well, no one's planning on getting married a third time, but it happens. So this way, the money is there. And the other good thing about having this type of will, like I call number 5, is that if you're leaving money to the spouse in this kind of trust, it is protected from Medicaid. I'd say it is protected from creditors. That's part of the spendthrift trust is it can't be attached by anyone. So they're very important thing. I've spent about 25 or so minutes talking about types of wills. Let's see. What we're doing now in the COVID is we prepare the documents, we mail them out we email them that email thing. And in our email, we say, okay, listen, here's what you need to do. You need to print it out, staple it together because the will is a separate document from the power of attorney. The power of attorney is a separate document from the living will. And then you're going to read the printed document. Um, the reason why I'm emailing it now is because if there's changes, it's easier to make. And we're sending people the documents as a Microsoft Word document. So if someone's name is simply spelled wrong, they can change it themselves and sign it at their convenience. And no one's name should, the only time someone's name is spelled wrong is when the client spelled their name wrong to begin with, because they're typing up and emailing us the names of the people. So we're cutting and pasting it into the documents that we do. So we email the documents, and then we're emailing someone like pays the attorney, and then we're also emailing instructions so that someone after they print it, they can sign at their leisure in front of a notary, either at the UPS store or if they work where they're at with two witnesses who they trust, and they're not as concerned about that person's germs. My office is in Edison, and we've been periodically signing wills by appointment in the parking lot, as long as it's not raining. Why the parking lot? Well, people are afraid of getting germs from us, and some of my law clerks are concerned about getting germs from someone else, and it's not that much extra work where all they have to simply do is have a 6-foot table brought outside, and we say, okay, sign here, sign here, sign here, sign here, and then we bring the documents inside. The people sit in their air conditioning, they sign, and we stamp the documents with the seal, and then the person gets the original. Now remember, only the original will can be admitted to probate. A photocopy of the will, can't be admitted by the surrogate to probate. Think of the surrogate as, again, a fancy name for the will clerk. Everything is right. The will clerk says, okay, the surrogate, original signatures, but also beware of these cheap forms online. Beware, beware, beware. I'd say what was happening was people were doing cheap forms online, and even though they places advertise it's good in every state, it's not good. It's not good, because a lot of times they miss things, or it's the people don't sign correctly. Sometimes it's signed the old way, and so under the old law, the person signed and the two witnesses sign, and then after someone passes away, they have to locate one of the two witnesses, and that witness had to go to the surrogate's office and sign paperwork, an affidavit to say yes, they watched the will. Well, a lot of times you couldn't find a witness, or in my experience, sometimes the witnesses try to extort money and say, yeah, I'll go to the surrogate's office and sign those papers. My fee's $500. And we said one time, we're not, my client's not paying you the $500. So then they said, well, get the other witness. Well, that person's dead. And they said, yeah, my fee's going to be $500. So the law was changed, and we have what's called a self-proving will attachment affidavit. Therefore, the person signs, two witnesses sign, the attorney notary signs, and then we sign again with certain witnesses. So that means that the witnesses don't have to be brought to the surrogate's office, and it makes life much, much, much easier. But I see a lot of these cheap things online do not have a self-proving affidavit, so the family has to find and locate witnesses. So they really have not saved any money. Now, also, the will has to have a clause that says no bond required. Otherwise, they have to pay this money for a bond. Why is that? Well, because that's the law. That's New Jersey state law. Also, the will should have a clause that says, who is going to be a funeral agent, or who, and typically it'll be the executor, but this way you want to have as many things done as possible ahead of time. And this, see, why do you go to an attorney to have things done? Because you're hoping the attorney will do it right. Let's see. People like think they can go on YouTube and watch how to get something done. And maybe that's okay for painting the side of your garage or certain things. But hey, I remember one time trying to do my own electrical work. I almost burned the house down. Now, if I need something done right, let's see, I hire a licensed electrician because it's too important for me to cheap out and burn my house down. And it's also too important, sometimes to cheap out to not get your proper legal documents done right, because it's going to cost the family much, much more in the long run. So after the will is signed, remember, only the original will can be admitted to probate. If you can't find the original will, then my rule of thumb, I tell people, listen, if you can't find it within 48 hours, you're probably not going to find it at all. A copy of the will is as good as a copy of a $20 bill that you lost. You can't go to the bank and say, oh, I lost my $20, I need a replacement. Has to be the original will. Now, if someone already has a will, it's important to periodically review it every 5 years or so. Number one, you still have the original. Two, you look at who are the executors. Are they still around, and can they do the job? Let's say, my grandfather was a smart guy, but when he was 90 years old, he did not run the 100-yard dash as fast as he used to, and he had trouble getting up and down steps. My rule of thumb on executors is, can they drive to meet with the surrogate, and can they walk up a couple steps? If they can't, then we're not being mean, we're being practical. Same thing with the power of attorney. Spouses usually make their other spouse the number one person on their power of attorney, but if that person is ill or had a stroke or can't get around, well, that's the person I would have to go to the bank on your behalf to do your business. So is that still the person that would be best for you? I'd say also sometimes the person that you picked as executor may not be involved with your family, or may not be the person you want. Are they in bankruptcy? Let's say some people are pending a divorce. Sometimes the people have substance abuse. So always think about, is this right for me at the present time? Okay, that is what we have on wills. Now we're going to talk a little bit about power of attorney, because we go for about 45 minutes, and this gives me about 11 more minutes to go. So the will takes care of your assets if you pass away. What is a power of attorney? A power of attorney is the document that says you're giving power to someone to be able to make sure your bills are paid, your assets are handled, and a power of attorney is either effective right away or only upon disability. And when it's effective right away, the person can start acting right away. And in legal terms, that's a durable power of attorney. A springing power of attorney means it only springs into effect if someone becomes disabled and there's a certification by a doctor saying that they fit the definition of this disability. Interestingly, one of my clients said, Kenny, I'm a carpenter. I'd say, you're using legal terms. Please explain to me in carpenter language this power of attorney thing. I go, okay. If it's effective right away, your son can steal all your money right away. If it's effective only upon disability, your son needs a note from a doctor, say you're disabled, before he steals your money. Knowing that, do you trust your son? Answer, yes, I trust my son with my life. Well, then make it effective right away. Let's see. So again, the power of attorney is effective either right away, only upon disability. Most people make it effective right away to give the power so someone can transfer real estate access. We also updated our documents to give medical access because under the HIPAA law, um, even a spouse can't talk to doctors. Um, so we want to have a general durable power of attorney. Now, here's a change in the law. Let's see. There used to be a time where the banks were giving people a hard time, saying, "Well, it wasn't done on our form, and it wasn't on the Wells Fargo form. We're not going to honor it." So it wasn't on no First Fidelity or First Union form. So New Jersey legislature got smart and they said, "Listen, if it makes language to New Jersey statute, any bank doing business in New Jersey, any financial institution, Morgan Stanley, Merrill Lynch, if it makes reference to New Jersey statute, has to honor it. No, no dispute. However, the power of attorney has to make access to the specific statute, which is Section 2 of PL 1991, C95 colon 2B-11, and I'm pretty sure some free document or cheap document online does not have reference to that particular statute. Sometimes banks or institutions give people a hard time saying, "Well, I don't know, we're not going to honor it." Well, if that's the case, then I tell the clients, file a complaint with the Department of Banking and Insurance, which regulates these kind of things. And usually then these institutions change their tune. However, I do recommend people sign a new power of attorney every 5 years, or if people's names change. You never have to sign a new will. A will that you sign this year is good 20 years from now. But the reason why I recommend a new power of attorney, it's not as complicated of a document. And especially when people's names change or addresses change. So there was a situation where mom had a power of attorney, and she gave the power to her daughter, but the daughter then got remarried, had a different last name, a different address, and mom became ill. The power of attorney's 15 years old. The daughter goes to the bank. The bank had never seen it before, and the bank said, "Well, your ID has a different name on it and a different address. How we know it's still you? How we know it's still good?" Now, there's no central repository in the state of New Jersey to, quote, save wills. They're not registered. There's no repository for living wills. They're not registered. They're not safe. However, it is a good idea that after the documents are properly signed and properly prepared and signed, you try to have the documents scanned and then forward that to the banks, forward it to your financial planners, forward it to your institutions so that they have it on their record and there's no dispute down the road when the person you picked is going to try to do the work. Let's see. We have a website, njlaws.com. We have detailed information on powers of attorney. We have detailed information on the njlaws.com njlaws.com website on wills. We have, information on probate, powers of attorney, Medicaid, etc. So in the short 45 minutes that we have, we don't want to go, you can't cover everything, but at least, okay, so we've covered wills, we've covered powers of attorney. The last document we're going to cover in the last 5 minutes is the Living Will Advance Directive. This is important to have. It is very important. Why? Because there's so many advances in modern medicine that doctors and hospitals have the ability to keep a body alive where the person is never going to regain consciousness, where the person is never going to walk the planet or open their eyes, or so someone is in a persistent vegetative state, the vegetable. Well, the importance of a living will advance directive is you're giving instructions ahead of time to doctors and hospitals, basically, typically saying, listen, if there is no hope for me, I do not want to be on feeding tubes. If there's no hope for me, I don't want to be on a long-term respirator, and other machines keeping me alive. Now, when the nation, like going through COVID, people were on respirators. That's a little different. People were afraid about living wills, saying, "Well, if I have a living will, does that mean they won't do CPR on me?" No. If someone has a heart attack or a stroke, and when they're at ShopRite buying vegetables, well, then they're going to bring you to the hospital and do the right thing. We're talking about where someone is unconscious, their eyes are closed, and there's no hope for them. You know, the Living Will Advance Directive has questions, and so the first section, and we just so there's no confusion, we took the language and parts of it directly from what the medical society uses, so doctors are familiar with it. So the first section deals with fluids and nutrition, and so someone's in a coma, irreversible condition, fluids and nutrition to be withheld or provided, and probably 85% of people now say, "Hey, listen, if there's no hope for me, I don't want to be on feeding tubes. I don't want to be on respirators. Let's stop it." Remember, the living will document isn't for you. It's for your family and the people you care about, so that the doctor does not have to ask them the ultimate question: should today be the day? Because again, I remember when a doctor asked me a question one time, basically saying, "I'd say, okay, listen, there's no hope. Should we pull the plug?" And I remember saying, "Doctor, geez, I feel bad. I feel bad. I mean, I know what the right decision is for someone who's 92 years old, that is never going to open the eyes, never going to walk the planet again. But again, you feel bad. It's like the doctor saying, okay, go over there and turn the switch off." So I couldn't even do it for my dog. When my dog was so ill, and the doctor on Amboy Avenue said, that guy, listen, there's nothing we can do. Your dog is suffering. I had to send my wife in. He goes, "No, you got to do it." So part of doing the living will is so that the family does not have to be put up with that agonizing question. The next section of the living will ask questions, deal with medical treatment and machines. And typically 99% of people say, "Hey, listen, if there's no hope for me, I don't want to be on feeding tubes and stuff like that." When I was first married, by the way, I remember I was redoing my documents, and when you're first married, you're all lovey-dovey. And I remember my wife saying, "Oh, I could never let them pull the plug on you." So I said, "Okay, fine, I'll leave my dad because he's logical like Mr. Spock." So then we advanced 25 years into the future, and my wife says, "So let me ask you this question. I'd say, yeah, if you die, I get $800,000 in life insurance tax-free, and I never have to work another day. Why would someone not, pull the plug?" Well, I haven't been sick, and we've been married 31 years in another month, so everything is good. The last thing on the living will asks organ donation yes or organ donation no, and we always recommend people sign yes. Just like the will and the power of attorney, it's a good idea to scan and send your living will to doctors. When you go to the hospital, bring a copy of that. I'm out of time. I want to spend 90 seconds on estates in New Jersey because I did not see questions in the chat box. New Jersey probate's easy. I'd say there's no estate tax. They did away with it. If the monies are going to spouse, children, grandchildren, parents, there's no inheritance tax. Let's say the surrogate doesn't follow up with things, you don't have, and as long as all the beneficiaries sign a paper we prepare called the release and refunding bond after you give an informal accounting, then there doesn't have to be court approval for people to give out the money. So believe it or not, New Jersey is a probate friendly state. I'd say, yeah. I've been in the Metuchen Edison area a lot of years. My parents moved to this area in 1962. I think I had my first communion in St. Francis in 1967. I got married in St. Francis, so I fished at Tommy's Pond, so I'm a Metuchen area kid. Let's see. I recommend everyone don't try to get who would have predicted that people were going to be prisoners in houses for months? Get your documents done while you can. Who would have predicted that people then would go to the hospital and you couldn't have documents signed, you couldn't see your family? No, so don't wait till the next national emergency. Get your document done. Let's see. A question, does a will have to be notarized? Yes, yes, and more yes. These people screw things up by preparing stuff and then having it signed. Again, think of the surrogate as a fancy name for the will clerk. If it's not properly signed and notarized, the surrogate cannot admit it to probate. Well, yeah, there's a mechanism where it's a scribbly thing, but that has to go in front of a superior court judge. A notice has to be personally served upon everyone who would inherit under the will if it was not, not properly signed, not notarized. And, the whole idea of making it easier is making it easier so that you don't have to look at, more stress, more work. My office is on Woodbridge Avenue at Edison, not that far away. So I suggest if everyone to have everything done. And oops, I'm trying to look at a little question. Let's say so. Let's say there are laws in New Jersey that say who gets if there is no will. Let's see, but the process becomes much more complicated. And if there's children from a prior relationship, then they get 50%. The wife gets 50% typically. However, if there's no children, someone's married, they don't have a will. Guess what? That person's parents get some of the money. So the whole idea of doing planning is to do things properly. I thank everyone for your attendance. I've went over my 45 minutes time, so whether or not it's me or someone else, it's a good idea to get your documents done. Thank you. Does the library have any questions?